The Supreme Court just gutted Section 2 of the Voting Rights Act, and I want to make sure you understand what that actually means, not just legally, but historically. Hey y'all, my name is Christina. I'm a cultural strategist, and I study how history and cultural memory show up in the present. And I went to law school and studied constitutional law, so let's get to it. Now, the Voting Rights Act still exists, but this past Wednesday's ruling in Louisiana versus Calais significantly weakened the part of it that actually had teeth. Section 2 is the provision that says states cannot draw congressional maps in ways that dilute the voting power of Black communities and other communities of color. It is what gave Black voters legal recourse when districts were deliberately drawn to make their votes count less. What this court did is raise the bar for proving that discrimination is happening. It is no longer enough to show that a map produces unfair outcomes. Now you have to meet a much stricter legal standard to even bring a successful claim. When the standard is higher, the law becomes harder to use, and that is the whole point. Now, Justice Elena Kagan said it plainly in her dissent. She said, "This decision allows states to dilute minority voting power without legal consequence." She called it an evisceration of the law. And she's not wrong. Within 1 hour of this ruling coming down, Florida's Republican-controlled legislature approved a new gerrymandered map. 1 hour. And it didn't stop there. Louisiana has already suspended its primary election to redraw its maps, and Tennessee's governor just called a special session specifically to break up the only Black majority district in the state, the Memphis seat. Alabama called a special session too. This is how it works. The ruling comes down and the redistricting starts immediately. And here's what I need you to understand. The Voting Rights Act was signed in 1965 because Black Southerners were being beaten, jailed, and killed for trying to vote. Fannie Lou Hamer, the Edmund Pettus Bridge, Medgar Evers, James Chaney. The people who bled for this law did not do it so that 60 years later, a court could quietly make it unenforceable. Now, this isn't new. This is the same fight in a different courtroom. Pay attention, y'all. And I mean really pay attention, not just to the headlines, but to what happens in your states in the next 30 days. I'll be back with more on this.